That's why Miss Gillette is doing this. My attorney already told me Miss Gillette does not like me. That comes from Miss Gillette to my attorney. That's a conflict of interest. And on the record and for the record, and let the record show.
Mr. Perez-Beal.
On the record, on and for the record, and let the record show, I have the right to face my accuser, and the accuser must be a living man or woman. Therefore, I move to dismiss the case entirely. Must my accuser be a living man?
Kansas versus Antonio Manuel Perez-Beal. Are you Antonio Manuel Perez-Beal?
Yes, sir, I am. Yes, Your Honor, I am.
All right. Mr. Perez-Beal, do you have an attorney?
No, I do not. But I do believe I have the right to face my accuser. And on the record and for the record, and let the record show.
Mr. Perez-Beal, this is your first appearance. You are charged in count 1 with criminal trespass, a Class B non-person misdemeanor. A Class B non-person misdemeanor is punishable up to 6 months in the county jail and a fine not to exceed $1,000. Do you understand what you're charged with?
On the record, on and for the record, and let the record show, I have the right to face my accuser, and the accuser must be a living man or woman. Therefore, I move to dismiss the case entirely.
Well, that's not going to be done. Mr. Perez-Beal, I asked you a question. Do you understand what you're charged with?
No, I do not.
All right. What is it that you don't understand about the criminal trespass charge?
I don't know why I'm being charged with a criminal trespass. I have a picture of me and my children over there on November 23rd or 27th. I'd have to go back and date it. My livestock, please let me finish, Your Honor. My livestock come up missing. Whenever that man, I had that leased. Whenever that man come down here, my hot wire come up missing. The fence that divided our two properties. He cut a hole in his fence. I have a witness who is a neighbor stating that he's seen a young man and a young woman out there removing that hot wire. I've never once had a problem. He showed up, our hot wire come up missing, and a hole got in the fence. Whenever that happened, I called one of your deputies, Deputy Joe Love. He showed up to the scene.
All right, Mr. Perez-Beal.
I have a right to look for my missing livestock.
Mr. Perez-Beal,
I'm filing an interlocutory appeal.
You need to stop talking for a moment. This is a first appearance.
Well, this is wrong.
Sir.
All right, folks, buckle in. Because this courtroom moment is a perfect storm of legal confusion, misplaced confidence, and viral-worthy drama. What we're about to witness is not just a defendant challenging his charges. It's a man attempting to challenge the very foundation of law itself. Antonio Manuel Perez-Beal, identifying as a living man, dives headfirst into the strange world of sovereign citizen ideology, where legal words are believed to hold magical power. But this judge, he's not here for games. What starts as a routine hearing quickly spirals into a verbal chess match, one side rooted in legal procedure, the other in pure pseudo-legal chaos. You're going to want to see how this unfolds. Here's where things start taking a wild turn. Notice how Perez keeps repeating the phrase, on the record, for the record, and let the record show. That's not courtroom etiquette. It's a line lifted straight from sovereign citizen playbooks. They believe that by stating something into the record, it becomes legally binding. The problem? That's not how law works. The judge is asking him a simple question. Do you understand your charge? And instead of answering, Perez is trying to outmaneuver the system with pseudo-legal jargon. It's like showing up to a chess match with Uno cards.
First appearance. At that time, what I do is I go over the charges, what the potential penalties are, and try to explain to you your rights. Please do not interrupt any further. Do not go off on tangents. I'll have some questions for you that you'll need to address. First of all, in regards to your rights, you have the right to a trial, either to the court or if you request in writing a request for a jury trial. At a trial, the state has the burden of proof. The burden of proof in a criminal case is beyond a reasonable doubt. At a trial, you have the right to be represented by an attorney or to represent yourself. You understand you have the right to, at a trial, to cross-examine the state's witnesses and to call witnesses on your own behalf. You may use the court subpoena power to be sure that other witnesses appear. Do you understand these rights?
Yes, sir.
All right. Now, at a trial, beyond the right to cross-examining the state's witnesses and calling witnesses on your own behalf, you have the right to either testify or not testify as you see fit. If you choose not to testify, then then that cannot be considered against you into determining if you're guilty or not guilty.
Must my accuser be a living man or woman?
Okay, Mr.
And there it is, the first real sign the judge's patience is running thin. Perez won't stop interrupting, and every sentence turns into a constitutional tangent. He's blending real legal terms like due process with random sovereign soundbites like under duress and false imprisonment. To a trained ear, it's obvious he doesn't understand what any of it means. But to him, these phrases feel like power. Judges across the country deal with people like this weekly. Defendants convinced that if they just say the right magical words, the entire court will have to bow down. Spoiler alert, it doesn't work that way.
Mr. Perez-Beal, I'm not sure where you're getting this.
The Sixth Amendment.
All right. This is the first appearance, as I've indicated before. Now, if you wish to be represented by an attorney, you can hire one or you can apply to the court if you choose.
Let's take this to trial. Jury, I want a jury trial.
All right. First of all, let's answer the question about the attorney. Are you going to represent yourself or are you going to hire an attorney?
I will, at this point, I'll represent myself. And if I have the fine.
You blocked out, Mr. Perez-Beal.
Can you hear me now?
And now I can hear you. The last thing I heard before it blacked out was in regards to you're going to be representing yourself and that you
I will represent myself unless I'm financially able to hire an attorney. But last time I spoke to my attorney, Mrs. Mary Ann Shirley, she told me that Judge Jill Gillette does not like me. That's where all this is coming from.
First of all, Ms. Gillette is not the judge. I am.
I said
you've been before me before.
Yes, sir. I know.
All right. So are you still on probation?
Yes, sir. As far as I know.
Well, if you're on probation and convicted of a new offense, that'll be a violation of that probation.
That's why Miss Gillette is doing this. My attorney already told me Miss Gillette does not like me. That comes from Miss Gillette to my attorney. That's a conflict.
The judge takes back control with surgical precision rather than arguing. He calmly goes line by line through Perez's constitutional rights, forcing him to acknowledge the basics: trial, counsel, cross-examination. It's a smart move. When a defendant starts spiraling, grounding them in procedure can neutralize the nonsense. Still, when Perez asks again if his accuser must be a living man or woman, you can almost hear the collective courtroom sigh. The judge's tone stays steady, but the message is clear. This isn't YouTube law. It's the real world.
Right now, you don't have an attorney on this case. Is Ms. Mary Ann Shirley going to be, are you going to hire her on this case?
I will talk to her, but Gillette knows what she's doing. She likes tearing families apart. What happened when Karma finally
Mr. Perez-Beal, you've indicated that you want a trial. And you also indicated that you wanted to have a trial by jury. To do that, you have to file a written request for a misdemeanor.
I have to file a written request?
If you are going to be representing yourself, you need to understand there's disadvantages in that. One disadvantage is I don't believe you have the training that an attorney has.
No, but I also don't have everything I make's going to try and keep our home and stay afloat right now.
Right. As I indicated before, if you wish to have an attorney but cannot afford an attorney, you can apply to the court. If you meet the financial guidelines, then I would appoint an attorney to represent you. If that may not be an attorney that you select.
I will talk to Miss Mary Ann Shirley.
All right. So if you're going to talk with an attorney, typically what we do is we schedule another hearing to give you that opportunity. And we call that a control hearing or a status hearing. Do you wish to do that, or do you wish to go ahead and schedule a trial?
If we schedule a trial and I show up with an attorney, will that be allowed?
And here comes a classic turn. When logic fails, blame the system. Perez insists that a woman named Miss Gillette has it out for him personally, even though she's not even the judge on this case. This kind of paranoia isn't new in these situations. Defendants often construct elaborate stories to justify why the legal system seems unfair. But as we see, the judge calmly corrects him, again, and reminds him who's actually presiding. It's a moment of quiet professionalism amid pure confusion, showing exactly how judges handle defendants who mistake suspicion for evidence.
Well, it would, but if you're asking for a jury trial, there's certain things that you have to do. Right now, you're representing yourself. That can be, you need to understand that the disadvantage that people have by doing that sometimes is more than others, but you will be required to follow the rules as you are an attorney if you're representing yourself. Most people don't know what those rules are and so forth. So that presents a real disadvantage at times. Do you understand that?
Yes, sir.
Okay. So if you're going to apply for an attorney or talk with Ms. Shirley, what I'll do is schedule a control hearing. That is not waiving your right to a trial. All right. If that control hearing or status conference, which we'll set in about 30 days, if you still wish to have a trial, we'll schedule that. We can schedule for either in person, either before the court, or you can be represented. If you wish to have a jury trial, you need to have your request made in writing for that. And we would schedule a trial by jury. Now, there was a hearing that was scheduled on December 13th, and you did not appear at that time. I issued a bench warrant, and you had been served with a summons. Now, later that day, you contacted the clerk's office, and then you did surrender yourself and posted a $5,000 cash or surety bond, and that bond is still in effect. All right?
Yes, Your Honor.
So
Yes, Your Honor.
This part is a gold mine for anyone who's ever watched a Sovereign Citizen video. Perez declares he doesn't stand under the charges, a phrase meant to reject legal authority. It sounds deep, but it's meaningless. What's fascinating is how confidently he says it. There's almost a rhythm to it, like a rehearsed monologue. The irony? Every word he speaks further confirms jurisdiction because he's participating in the process. The judge, probably suppressing a laugh by now, keeps his composure while Perez keeps digging deeper into the fantasy. It's courtroom theater at its finest.
be sure that you appear as directed for later hearings. Now, let's go ahead and schedule this for a control hearing to give you an opportunity, Mr. Perez Beal, to speak with an attorney of your choice or to apply for an attorney. Please do not wait until the last minute to do that hearing, if you're going to apply. If you're going to apply, do so in the next few days. If you're able to hire an attorney of your choice, that's fine. Then the court-appointed attorney would be released from dealing with the case. All right. Now, January 31st at 3 p.m.
January 31st at 3 p.m.
Okay, Mr. Presbiel, you're breaking up a little bit
And
on your connection.
can you hear me fine now?
Well, it comes and goes. Right now, yes, I can hear you.
Can you hear
Now we can't hear you.
fine now?
There's also a time delay. I'll see your lips move, and then we'll hear the sound. We call it lag, or I call it lag. Mr. Presbiel, now you're frozen, and we haven't been able to hear you for the last 30 seconds or so.
I'd just like to make a statement.
Well, you've made some statements, but
Can you hear me
right now
now?
we're scheduling January 31st.
Now Perez decides to represent himself, a move that rarely ends well. Judges typically warn defendants against it because they know what's coming. Misfiling, procedural mistakes, and endless confusion. Perez insists he can handle it, but also admits he's broke and emotionally strained. It's a tragic mix of pride and frustration. The judge, staying patient, offers him another chance to get counsel and schedules a new hearing. Even after all the bluster, the system still gives him the same fairness it gives everyone else. That's the quiet dignity of real justice. It keeps working even when people...
Now, are you able to hear me?
Now I was able to hear you. You interrupt me, but our next court hearing is January the 31st at 3 p.m. That will be a Zoom hearing. You understand? Do you have that? Mr. Presbiel, did you hear the date?
Yes, sir.
Okay. Can you repeat the date so I know that you've got it, please?
January 31st at 3 p.m.
Correct. Because
By Zoom.
that'll be a Zoom hearing, but I want you to appear at the sheriff's office so that we don't have this problem here. If you have an attorney and the attorney would prefer to have you there at their office to do the hearing, then that's fine too. So if Ms. Shirley is going to be your attorney, you hire her, and she wants you to be but you need to be at one of those two places, either the attorney's office or at the sheriff's office where they have the equipment, and we can be relatively sure that you're going to have a good connection. Because in this hearing, we haven't had a good connection.
Yes, sir.
All right. That's the things that we needed to cover for today. So this matter will be adjourned, and we'll see you on January 31st at 3. So Mr. Presbiel's case is adjourned at this time. All right. Next matter we'll take up is... All right. I need you to mute him.
And just like that, the hearing fizzles out. Not with dramatic ruling, but with lag, confusion, and yet another reminder that reality always wins over fantasy. Perez's case continues, but the outcome here is already clear. No amount of YouTube law can rewrite the Constitution. The judge's patience and professionalism stand in sharp contrast to the chaos in front of him, and that's exactly why this clip went viral. It's the ultimate clash between fantasy and the rule of law. If you found this case as unbelievable as we did, hit that like button. Drop your thoughts in the comment below. And don't forget to subscribe for more courtroom breakdowns where logic meets chaos and justice always has the last word.